Hello and welcome to this video on petition for children of U.S. citizens and permanent residents. U.S. citizens and permanent residents, LPRs, can petition for the green card of their adult children. The children's age, marital status, and country of birth play a role in the immigration process. Definitions. In general, under immigration law, a child is an unmarried individual under 21 years old, and a son or daughter refers to someone 21 years old or older. Petitioner is the U.S. citizen or LPR. Beneficiary is the child, son, or daughter. Immigrant visas, IV, or green cards are available without numerical limitation for immediate relatives. Under immigration law, immediate relatives are children under 21 years old of a U.S. citizen, spouse of a U.S. citizen, parents of a U.S. citizen. Immigrant visas for the preference categories are different because they are subject to annual numerical limits. That means there is usually a long wait for the visa to become available. The priority date is the date that Form I-130 was filed. The priority date is essential to estimate the date the immigrant visa will be available. Get up-to-date monthly visa availability timeframes by visiting the National Visa Center Visa Bulletin page on the link below. Relevant preference categories. First preference, F1. Unmarried, adult sons and daughters of U.S. citizens. Adult means 21 or older. Second preference, F2B. Unmarried adult sons and daughters of LPR. Third preference, F3. Married sons and daughters of U.S. citizens. Due to the immigrant visa numerical limits, the wait for a visa in this category can be years. Therefore, there is an advantage to filing as soon as possible. See the chart below for a comparison of the immediate relative category versus the preference category. Required documents for the I-130 petition. Form I-130, petition for alien relative with filing fee, evidence of U.S. citizenship, a copy of the U.S. birth certificate, a copy of the unexpired U.S. passport, a copy of the consular report of birth abroad, a copy of the naturalization certificate. If the name of the petitioner or beneficiary changed, submit proof of the legal name change. For example, marriage certificate, divorce decree, adoption decree, court judgment of name change. Proof of relationship is the son or daughter's birth certificate. The certificate proves that the beneficiary is the son or daughter of the petitioner. Process of filing the petition requesting the immigrant visa at the U.S. Embassy or consulate abroad. The I-130 can be submitted by mail or online. Keep in mind that online submissions are processed faster. Follow the form's instructions and send all required documents the first time to avoid delays. USCIS will mail a receipt confirming that they have received the petition and listing the priority date. USCIS notifies by mail when the petition is approved, and the case is moved to the National Visa Center to wait for the immigrant visa availability. When the immigrant visa is available, the NVC will notify the petitioner and the beneficiary applicant to proceed to apply for the immigrant visa. The beneficiary and family, if any, will complete the DS-260 online and pay the visa fees at cacstate.gov. The DS-260 is the immigrant visa application. Beneficiaries who have a valid tourist visa before the I-130 process starts can use the visa. However, generally, they cannot apply for a non-immigrant visa while the immigrant visa process is pending. If the beneficiary lives in the U.S., the beneficiary must have a valid status when the immigrant visa becomes available. Then, submit Form I-485 to adjust the status. To learn about this process, watch our video on Form I-485. Thank you for watching. Subscribe to www.𝗏𝗚𝐴LIUS.com. New courses available.